Before we begin, we'd like to give special thanks to all of our sponsors for helping make this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 5 consecutive years. And thank you to our platinum sponsors, Orasure Technologies, Psychmedics, Samba Safety, UKG, and Quest Diagnostics.
Hi, and thank you so much for joining us for another session of Day with DISA. Today, we're talking about a up-and-coming topic in the world of background screening. We're talking about social media searches, and specifically what you should know as HR professionals. So today, we're joined by Todd Higey, General Counsel at Global HR Research, which is a DISA company as of a couple months ago. Todd, how are you doing today?
I'm doing great, Thomas. Thanks for asking.
Yeah, absolutely. Well, we're excited to have you here. This is a topic we get asked about fairly regularly, but before we jump into the presentation, I do want to remind everyone, if you have any questions, use the Q&A button at the bottom right of the player. Any questions we're unable to answer today, we will reach back out to you after Day with DISA. We'll work with Todd to get those answered and get you an answer back. Additionally, we'll make a copy of this presentation available for download on the Materials tab after the session. So again, at the end, just click on that tab. You'll be able to download a PDF of it. It'll be great. With that being said, Todd, the floor is yours.
Thanks, Thomas. Good afternoon, everybody. I look forward to speaking about social media screening with you all today. It's a very interesting topic, one that I have been working with now for the last 5 or 6 years, when social media screening really got started back in 2017, 2018. And so I've got some experience over the last few years seeing the social media screening reports, having them come through, taking a look at them, interfacing with our customers, and providing input and context for them. So I think today should be very exciting and interesting for you all. Of course, as Thomas mentioned, I am General Counsel for Global HR Research. That means I am the lawyer for Global HR only. As you know very well, I am not your lawyer. And so anything I am saying here today is intended for educational and informational purposes. What I'm really wanting to do is to get you thinking, to give you some thoughts, to give you some ideas and concerns that you may want to take back to your legal counsel. And as you're going to see further into our presentation, I'm going to lay out for you some suggestions on how you go about implementing and executing on a social media screening program. And in doing so, you're going to want to reach out to your employment law counsel. And hopefully what this presentation will do will inform you as to the issues that you need to think about as you are launching and deploying your social media screening program. So I want to start with a case study out of Pittsburgh, Pennsylvania, called Ellis versus Bank of New York Mellon Corp. This case was from a few years ago. It arose out of an incident in June of 2018. Where a city councilman of a suburb of Pittsburgh was arrested after he drove his car through a crowd of demonstrators. These demonstrators were protesting the untimely death of Antoine Rose Jr., who had been just the week prior shot and killed by East Pittsburgh police. I've put there for you an actual photograph of the incident. You can see his black car there. Driving through the crowd of demonstrators. And so he was arrested for that. And as you might expect, that was a big item in the local Pittsburgh news. Well, one Saturday, a lady by the name of Lisa Ellis, and the reason I can share this information is because it's a published case. So I'm not conveying anything that isn't already out there in the public sphere. But Saturday after the arrest, she is apparently, I'm assuming, at home on Facebook, scrolling through her feed, and she sees apparently an article about this incident, and she decides to comment on it. Her comment is, quote, "Total BS. He should have taken a bus to plow through." Now, Miss Ellis advertised herself on her personal Facebook account as a vice president for Mellon Bank. Well, as you might imagine, this public post did not go over well with a number of people. And within hours, within days, people were already reaching out to Mellon Bank. They were posting on Mellon Bank's Facebook page. They were reaching out to the ethics hotline. All the various social media platforms were being utilized by citizens complaining about this post. For example, this one here says, "A man runs over protesters in Pittsburgh. He gets charged for his crime." And this is the VP Bank of New York Mellon's response. He quotes her, "Does Mellon allow their employees to promote attempted vehicular homicide? Does this represent your core values? If no, what's your policy on social media presence of professionals that represent your customers? Excuse me, your company. Answers, please." Right? So right away, Mellon is being put on the spot for this post by a lady who represents herself as a vice president. I wanted to mention she was actually a control group project manager. So not only did she make a post, but she described her title a bit differently than what it actually was with the bank. Here's another complaint received by Mellon through its ethics hotline. "Our community is in a lot of pain. We're exercising our right to protest. In light of all of this, one of your employees made a disturbing and inhuman post regarding this man's actions. Mellon, do you allow your employees to act like this and represent your community?" Obviously, what we have here is a reputational risk. And, I've seen this occur over the years. Often a higher placed individual within a company makes a post on social media, and boy, it does get a lot of attention in the community. And people reach out to the company and say, "Does this represent you?" And so in this particular instance, as you might imagine, Mellon Bank rapidly engaged in an investigation, interviewed Miss Ellis, did their due diligence, and they let her go. The reason why it's a published case is because Miss Ellis turned around and filed a Title VII claim against Mellon Bank, saying she was treated differently than other people who had posted on social media. And ultimately, the court concluded that nope, her comment was different, of a different character, of a different type than the others, and that the other comments by other employees were not comparable. And so the judge ultimately threw out the case and ruled in favor of Mellon Bank. But obviously, reputational risk is one reason why employers are interested in social media screening. And indeed, we've had some employers come to us over the years and say, "Hey, I need to do social media screening because of reputational risk." Of course, that's not the only reason you're going to engage in social media screening. You're also going to want to engage in it out of a concern for harm to your employees, to the public, and to your property. So for example, if someone publicly admits that they are a violent person or have engaged in violence, that's something that's going to be of concern to you. Because if that individual, after becoming your employee and in the scope of employment, hurts somebody or steals somebody's property, that injured person is going to point to that public post and say, "You knew about this. Why did you do this and hire this person and allow them to hurt me?" We're going to talk about that more later in the presentation. But first, what I'd like to get to is what I call the mechanics of social media screening. I want to show you what it is, how it works, what it's not, what to expect when you look at a social media report. And then once we've done that and you've gotten a good feel for what social media screening is, Then we're going to move on to talk about, why do you do it and what is the legality? Do I, as an employer, need to be concerned if I look at somebody's social media posts? And then I want to conclude this presentation by discussing what a social media program looks like and how a program can be used to navigate and avoid pitfalls, successfully using this tool to protect the company, to protect employees, and to protect the public, while also respecting the rights and concerns of the employee or the worker. So these first few slides are going to be just words, no pictures, no graphics, but let me get through them, and I will then actually show you some real world examples, and you can see for yourself some of the things that we encounter in social media reports. So there are 4 steps to a social media report being prepared. The first step is an automated step. It's the use of proprietary software application, okay, owned by a company that developed it. And they take this application and it goes out there and it searches social media platforms, okay? One thing you're going to see me emphasize several times is this software application is only looking for publicly available information. All right. It is not looking at people's private posts. If someone has set their account to be private and there is no public component to it, then the software application is not going to go look at that. In other words, we don't engage in jailbreaking, i.e., let me crack that person's password and get into his or her private account. Likewise, no attempt is made to friend the individual. No attempt is made to connect with that person's personal network. Only public information is looked for. And what this application is looking to do is to find any accounts that may be owned by the candidates. Of course, you see there I say licensed, because really you don't own your social media account, although you may own perhaps the data on the account, although you need to read the fine print on that. But you get the point. The computer software application is using special proprietary technology to go out there and see if it can find accounts for your subject, your applicant for employment. Once potential accounts are found, we move to step 2. This is where a human comes into play, a social media analyst. And the first thing that social media analyst does is evaluate whether the account discovered matches the subject of the report, the candidate. Typically, 3 identifiers are going to be used. We want to make sure we've got a solid match. The last thing we want to do is attribute inflammatory speech or conduct to someone that it doesn't belong to. So 3 identifiers are used. And indeed, the analyst will consider like broader contextual information that might exclude a match. Well, this person couldn't have, wouldn't have been old enough to have made this post at this time. Or, we know our person lives in California, but here this post suggests the person was living in a different location, and given the context as a whole, we don't believe it's this person. You can see this little chart at the bottom. Typically, they're going to find one from each of these columns to use to match. I will say most of the time there is an image of the person's account. Most people post a picture of themselves on their social media account, and often as not, actually more likely than not, you're actually going to have that person's photo in the social media report. And I'll show you an example of that here in a couple of slides. Having determined that this account belongs to this candidate, the social media analyst then begins to review the publicly available information posted by that candidate. And they're looking for 4 categories of information. Information that relates to potentially unlawful activity, information that relates to potentially violent behavior, demonstrations of intolerance, and depiction or display or discussion of sexually explicit material. One of the things the social media analyst is going to do is figure out whether this information is what we call obsolete. Obsolete means it's too old. And under federal law, the Fair Credit Reporting Act in particular, which applies to social media reports, as you'll hear me discuss, if the content's older than 7 years, it's not permissible for us to give it to employers. So that's one thing you need to keep in mind with your social media reports. If you get a report and there's no adverse information in it, and then independently someone brings to your attention, for example, a coworker or a fellow employee says, hey, why did you hire that person? Did you see what they posted? And you see that post was from 9 years ago? Well, then you know right away, that was outside the scope of what my background screening company could supply to me. So keep that in mind for all social media reports. We finally get to step 4 once we have identified relevant information. The report is generated, and it's got 3 components to it. The first component is a report to you of how that identity match was made. What information were we looking at that's from the candidate that we're matching against what was on the social media profile, including, of course, a photograph or profile picture. It will then, in the second part of the report, provide a screenshot of the questionable content, and again, the publicly available content, and it will identify for you the category under which that content was flagged. So what you see right here are 2 redacted versions of a social media background check report. On the left-hand side of your screen, we have the basic report. On the right-hand side of the screen, we have a comprehensive report. I'll explain in a moment the differences between basic and comprehensive. But you can see here at the top where those orange arrows are located. And of course, since these are actual social media background check reports, I have redacted the identifying information. But where you see that big black square on the upper left, that's actually the photograph. Immediately to the right of that is the name, the street address, the telephone number that was available on the profile, the email address that was available on the profile. You can see on the right-hand side where our social media analyst is able to discover, for example, education or employment, like Bank of Mellon from that case study I had shared with you earlier. That too will be provided. So all of this information is transparently given to you as the employer, and of course also to the candidate, so you can see why we decided to attribute this post to your candidate. In the center portion of the page, you'll see a summary of the types of content that were flagged. You can see on the left-hand side, illicit drugs, intolerance, marijuana, and sexually explicit material were flagged. And then, of course, the right-hand side, expressions of intolerance and sexually explicit material were flagged. Down here in the bottom portion of the report, it will give you the source of where the flagged information came from. So you can see on the left-hand side where you see the number 10 plus in red by the Twitter symbol. That means the posts were identified on Twitter. On the right-hand side, you can see that there are 3 posts that were identified on Instagram and 3 that were identified on Twitter. And then, of course, at the bottom here, the social media report will tell you which accounts they were able to confirm. So, important point for you to be aware of. When we have a social media report that we supply to you, and there's no adverse, no derogatory information, okay? So there's going to be no flagged content and no flags. The report will still disclose to you the accounts that were confirmed, okay? So down here at the bottom, the analyst was able to confirm a match to the Twitter account and to the LinkedIn account. So even though you're going to have a clear report, we're going to tell you what accounts we were actually able to connect to and review. And you can see on the right-hand side, they were able to confirm in this particular instance, Twitter, Pinterest, Instagram, YouTube, LinkedIn, MySpace, and SoundCloud, all as accounts belonging to this candidate and which were reviewed for content of concern. So what are the two types of reports? You have the basic report and you have the pro report. The basic report is going to hit what I call the big 5 social media platforms, Twitter, Facebook, Instagram, LinkedIn, and Pinterest. And it only is going to look at 3 years of content, okay? The pro report casts a much broader net. And so you'll recall from the prior screen on the right-hand report down at the bottom, there were multiple social media accounts that were discovered and examined. That's because the pro report casts that very broad net looking at well over 100 platforms. And it's going to go back 7 years in its examination of potential information. One thing before I get to the examples, because I'm going to show you here some examples in a few slides, it's really helpful for the reviewer, the HR reviewer, to understand the types of posts that get flagged, okay? So one common type of post is simply liking or following objectionable content. And you're going to see examples of that where the person did nothing more than say like, okay, or I follow that, but there's no additional commentary. Sometimes the candidate will repost an objectionable statement, like retweeting an objectionable statement. And I bring this up because, you know, as an employer, you may want to make a difference between 1 and 2 and 5 and 6, right? Because down there at 5 and 6, that's where the subject or the candidate on their own generated the objectionable statement. They're not just retweeting it or reposting it. They're typing up the actual objectionable statement or the objectionable visual content. And then in between, of course, you have this hybrid where you're perhaps reposting an image or a meme, and you're adding your own commentary to it. And your commentary itself may be objectionable. So those are the 6 types of posts that a reviewer of the report may want to keep in mind. And not to get too far ahead of myself, when you're crafting your social media screening policy, you may want to give consideration to that. And you may want to put heavier weight on subject-generated content versus merely liking or following. Again, that's a decision you've got to make. One subject that I want to touch upon before diving into the types of flagged content is this issue of quasi-private to public. And here's how I've seen it come up. A social media report may come back clear with no adverse or derogatory information reported. 6 months later, the employer, perhaps from a coworker or perhaps from the general public, surfaces an objectionable statement or comment by that worker. And so naturally the employer says, well, did you miss it, background screening company? Why didn't you report it? The thing you have to keep in mind, as I think we're all aware of, if we really just kind of take a moment to think about it, is the fact that information that was once private or quasi-private can subsequently become public. So at the time we conduct a search, it may not be publicly available information, but then it becomes public, even though when it becomes public, the original date stamp is, so to speak, backdated. So I picked Peloton as an example, right? You have to register to become a member of that community. Only members can participate in the forum. Those communications within that closed group are semi-public, right? People within the group can see those posts. But if you're not a member of the group, you can't see it. But you know, as those communities grow, those communications bleed into the public internet. And then, of course, other members may repost and screenshot comments and pictures onto a public site. At some point, users, of course, may decide to automatically and simultaneously post content across multiple platforms. So you kind of have to keep that in mind, that it evolves, it's organic, and it's not necessarily static. And so, you know, when a social media report is being done, the examination is done and it's a snapshot in time. It's that particular day, what is publicly available. All right. So let's talk about the 4 types of flagged content. These are the 6 basic categories for unlawful activity. Photos, videos, references relating to drugs or marijuana in particular, references to theft, fraud, or property crime, such as, a reference to successfully shoplifting at Walmart, references to solicitation, not just prostitution, but perhaps soliciting someone to commit a crime, references to underage alcohol consumption, as well as to other potentially unlawful conduct. And one of the reasons that these categories are broken out is if you so desire as an employer, you can fine tune your report, and you can ask your background screening company, hey, I would like categories 1, 3, 4, 5, and 6, but I don't want category 2 on my report. I don't want to see the marijuana posts. Okay, maybe I'm in Colorado, maybe I'm in California, and I just don't want to see them. And so you can actually fine tune your report. And so it's helpful when you go to establish your program to think about, is there content I just don't need to see? Okay, so here's an example of potentially unlawful activity. You'll see there the post on the bottom, cocaine makes me want to listen to twiddly twang bluegrass or skippity bing bong bing gangster rap. What's up with that? Right, so that's presumably an admission of cocaine use, which is unlawful activity. That's my only unlawful activity example for you. We actually don't see that as often. What we tend to see more is the violent behavior, the sexually explicit posts, and the intolerant posts. We don't actually see the unlawful quite as often, but it is nonetheless there, and it does get flagged from time to time. So let's talk about potentially violent behavior. So this falls into 4 categories: aggressive online behavior and cyberbullying, displaying or using force or violence, expressing a desire to commit violence, expressing approval of unlawful violence. And, items 3 and 4 are the ones that we typically see the most. Here's a good example. Before I go over the specific examples, note that first flag there where it says site advisory, excessive flags, more than 3, additional content not captured. A nice feature of these reports is if there are a lot of posts, instead of giving them all to you, there's a site advisory. Hey, we saw a lot of this kind of content. Here are 3 examples. So this first example is an example of someone who took presumably existing content, a poster or meme or whatever you want to call it, and made her own commentary, which is thought for the day. I would only want to bungee jump if I could slap someone at the bottom and bounce away while giving them the finger. You may not care about that in hiring a person, but it's something that would get flagged. Here's another example of user or subject generated content. It appears in this instance, the candidate took a photograph of the back of someone's car where it depicts an image of someone execution style shooting someone else who is apparently a pedophile. And so that, the person that posted it presumably approves of that. And so again, depending on your social media policy, this might be something that would be worth having a conversation for. And depending on the position of the worker, you may have some concerns about your workers posting this publicly, especially if they identify you as their employer. Here's another example. It's a tweet where twice, there's 2 different tweets, I believe, thank you at so-and-so for making me want to punch you in the face for that picture. Have fun at mug night, little winky emoji. So maybe that's in jest using the word punch. We actually see a fair amount of those sorts of expressions of violence, but you can tell from the context that, it's meant to be a joke. This next one is classic expressions of exasperation. Oh my freaking goodness. If my neighbor doesn't stop making this creepy zombie yelling sound, I'm going to throat punch him. I might have to punch a ref in the face just cause. That's the third one. So again, these are just some examples of the type of information that will return. Continuing on, here's an interesting use case. First off, as you can see at the top, there's a flag indicating that there is other similar content across multiple accounts. And this one here, is this an expression of violence or is this an expression of sports where the Bengals are beating up on the Steelers and the Browns are enjoying it? That's for you to decide, right? But again, that's some of the information that will come back. Here's one. Apparently, this is an example of where it's subject-generated content commenting on something that the subject is posting. Very similar, incidentally, to the Lisa Ellis case, right? Where you're reading an article and then you publicly comment your thoughts on that article. Here, apparently, a fellow was accused of shooting a 5-year-old in the head, and the man says something along the lines, cynically, that it will come out he was high on something, then take a plea to get life in prison. Expletive, this guy, kill him immediately. Again, this is the kind of content that's coming out. Here's one where a person posts a video or a screenshot of a video and then includes his own commentary where you see the orange arrow. When your kids won't bleep, shut, bleep up, and then a lady appears to be gouging the eyes of a kid. I need a case of this, maybe two, says the candidate. Okay, there is violence. And again, this is a selected example. And one of the things you have to keep in mind is I'm picking deliberately the more mild posts. There is stuff that is rather shocking. On a personal note, I'm like, I can't believe people actually post that kind of stuff. But one of the things I need to stress to you is you are actually getting the mild stuff, because I didn't want to put the very offensive stuff on this webinar. It just wouldn't be appropriate in this context. But be aware, when you order these reports and you start getting them, you're going to see some stuff that's going to raise your eyebrows. Demonstrations of potential intolerance. Okay, 5 categories here. You utter or like a statement that's derogatory of a protected class. I imagine many of the attendees here are in the HR space. You know exactly what I'm talking about. Or posting or reposting an image or video, again, related to and derogatory of a protected class. I'll show you an example of that here in a couple of slides. Admitting you engaged in potentially unlawful conduct. I didn't hire that candidate because I don't think women can do that job. Well, someone who says that and says it publicly is basically admitting that they violated Title VII of the EEO laws. Use of derogatory nouns or adjectives, the N word, the B word, the C word, they're going to be classified as potentially intolerant, irrespective of the race, sex, or national origin of the speaker. Okay. No judgment is made on, okay, if this person uses the N word, the B word, or the C word, we're not going to flag it. But if this person does, we are going to flag it. It's just, if you use it, it's going to get flagged. As the reviewer, you're going to have to evaluate the context. And then keep in mind, sometimes behavior is flagged as intolerant, even if it doesn't necessarily relate to what I would call a protected class. It's not immediately apparent that, oh, this is a violation of Title VII or the ADA or the ADEA. But nonetheless, it's an expression of intolerance toward humanity in general. And so it will be shared or provided. Okay, this next slide is a straight up, no questions asked. We all know what this is, right? This is a candidate who posted this picture, and you can see the comment that was made by his colleague there. So certainly those kinds of posts are going to be brought to your attention. Here is one where this individual is tweeting at this, I am Steve Harvey. I don't know if that's Mr. Harvey's actual Twitter account, but expletive you, Steve Harvey, you ain't for black people, expletive. Okay, that's subject generated content. You can see it's flagged. And so again, as a reviewer, you can evaluate, is he expressing intolerance toward a protected class? And again, the class of the speaker. In this instance, the race of the speaker is not taken into account. We're just looking at what is said. Here, the subject shared a video that uses derogatory language toward disabled people. So you can see there's no additional comment or commentary on the post, but if you were to happen to listen to the video, apparently it uses derogatory language toward disabled people who obviously are protected under the Americans with Disabilities Act. So that sort of content will get flagged and posted. Now, here's a very important topic, okay, and one which has come up over the years and one which you need to be aware of, all right? And I need you to follow with me here on my 4 observations, okay? There is speech which the majority of readers would consider to be purely political in nature. I believe, President Biden is a good president, because he supports this cause. That's a very benign statement, right? And it's political in nature, and there's nothing inflammatory about it. There is speech which the majority of readers would consider to be an expression of animus against others, but not necessarily directed toward a protected class. I'll give you an example. Perhaps someone says, I really hate Nazis. Well, Nazis are not a protected class. That is still an expression of animus, okay? Is this political speech? Is it intolerance? You can see it's a very gray area. There's speech which I would say a court of law or a jury would consider to be an expression of an intent to discriminate on the basis of a protected class. I believe we should never hire women. I believe we should never hire disabled people. This protected class is not fit for XYZ. So there is speech, again, which the majority and a court of law and a jury are going to say, yes, you're targeting a protected class. And then there's speech where reasonable people are going to differ about, okay, is that political? Or is that violating EEO laws? Or is that just an expression of, I don't like someone, but they're not protected, okay? The social media analyst has got to make a judgment call on whether the speech is political. So keep in mind, sometimes there is going to be speech which is inflammatory, even incendiary, but yet the social media analyst in good faith concludes it's political and not intolerance and doesn't report it. Okay, this is inherent in the nature of this kind of report. You need to be aware of that because from time to time that might occur, because a political opinion may still be a controversial opinion, and a political opinion publicly expressed on a social media account where that individual is connected with your company might reverberate back. For example, the whole issue involving Walt Disney and the bills that were introduced and passed in the state of Florida regarding education and gender. Okay, comments on that could have easily been in any one of these 4 categories. And that's just a reality that is inherent in the social media report. Okay, last category, the sexually explicit material. I'm not going to give you any examples of this. You would be, maybe you wouldn't be, shocked at the kind of stuff that people post, both verbal content and pictorial content. If you use terms that are vulgar or crude or offensive and typically describe a sexual act, or if you repost or like such images, songs, or videos, that's going to get flagged and it will be included. Which, by the way, you need to take into account who in your department is going to review these social media reports, because it needs to be someone who understands that he or she is going to see some offensive content. All right. Is it legal? Is social media screening legal? I have certainly had that question over the years, and it's certainly one which deserves some consideration. So in evaluating it, let's stop for a moment and touch upon something that really arose out of the case study and some comments I made in the case study, which is, why do we conduct background checks in the first place? So here I've quoted something called the restatement of agency. This is something that lawyers use when they want to find out what's the classic legal rule, the classic legal principle on this subject. Let me go to the restatement of agency because it's kind of a summary of what you typically find in most states, in most jurisdictions. So here you see the word principal, substitute the word employer in your mind. You see the word agent, substitute the word employee, third party. That could be your customer, for example. So if you conduct as an employer an activity through an employee, and that employee harms that third party, the employer could be liable for negligent selection, training, retaining, and supervising and otherwise controlling that agent, right? That's the basic principle, negligent hiring. Why did you hire this person? Given what they said they would do and given how they behaved in the past. And for those of you in certain industry verticals, if you have a special relationship with that third party, a patient, a child, a vulnerable elderly person, you owe a duty of care to that third person as a general principle for harms that arise out of that relationship, including if your employee hurts that person who's been entrusted to your care. Okay, so that's obviously one of the big reasons why you would want to do a background check in general, as well as, of course, a social media check in particular, because a critical component of negligent hiring, again, as a general rule, and it's not the only component, but a critical one, is what we call foreseeability. That is, was it reasonably likely that I could foresee that this would happen if I hired this person? Now, normally, this is a question for a jury. Most judges, in most scenarios, are going to say, look, I'm going to let the ladies and gentlemen of the jury decide whether this prior criminal act, this prior conviction for robbery or theft or abuse would make it foreseeable that if you hired the person, they in turn would hurt somebody else, such as a customer or as a patient. These third parties are definitely going to argue, hey, you should take publicly available information into account. I mean, they do it. Those of you that have been involved in this litigation know it. And of course, if there are prior criminal convictions, the injured third party is going to point to those convictions and say, aha, see, you were on notice. This was a violent person. This person was a thief. You shouldn't have trusted them. You shouldn't have hired them and put them in this position of power over me. Same logic applies to statements made publicly by the employee. They will be used by that injured third party against the employer. You can see why Bank of Mellon was so concerned, because these public statements in the public's mind are attributed to the employer. But of course, negligent hiring is not your only concern in HR. You want to make sure you don't discriminate on the basis of a protected characteristic when you hire somebody. You want to make sure the candidate has the minimum legal qualifications. And during that hiring process, of course, you don't want to create any unfounded promises about job security or the like. This is, you can see I quoted a basic legal treatise on what are classic concerns. Okay. So what is it we want to be concerned about then and give consideration to in the social media report context? What do we want to consider and be mindful of as I'm looking at this report with expressions of potential intolerance, sexually explicit expressions of violence or unlawful behavior? What are the things I need to be mindful of? Well, look, a social media report is a background check report. And as you all know, when you go to order a background check report for employment purposes, you have to certify you're not going to violate federal or state equal employment opportunity laws or regulations. We all know what those laws are. Title VII, the Americans with Disabilities Act, the Age Discrimination in Employment Act, the Genetic Information Non-Disclosure Act, Pregnancy Discrimination Act, so on and so forth. So all of these laws are laws that an employer is going to want to be mindful of. Typically speaking, how does an employer go about proving they didn't violate an EEO law when making a hiring decision? Well, one way to do it is to establish standardized, objective, neutral, and validated selection procedures. Okay, so I'm sure many of you are familiar with the Uniform Guidelines on Employee Selection Procedures published by the Equal Employment Opportunity Commission. So certainly one way to go about showing that your hiring criteria doesn't violate EEO laws is to validate your selection procedures in conformity with the guidelines established by the EEO. Another common way is, and I do this a little bit tongue in cheek, is ignorance, right? If you didn't know someone was a person of a protected class, how could that have been something I took into account when I made the hiring decision? So as we all know, it's very common practice to avoid asking certain questions, not necessarily because the question in and of itself is illegal, and not even because receiving the information is illegal. In some instances, it could be, but because you just simply don't want to know it, so you can't be accused of using it. So instead of saying, do you have any physical disabilities? Typically, the classic recommended question is, can you perform the requirements of the job with or without an accommodation? And so the idea there is I put on blinders and deliberately only want to obtain the information that is relevant to the hiring process, and which is not relevant, I don't need to know, because I don't want to be in a position where someone thinks I've discriminated based upon a protected characteristic. It's not just EEO laws that you need to be mindful of. There are the so-called protected password laws, or what I call the social media account laws. So here are the states in red and blue. Both of these colored states have laws on the books which provide protections to workers and candidates who have social media accounts. So the states that are colored in red have what I call, standard account protections. I'll describe them in a moment. The states in blue have protections that expressly carve out public record information or public information from the scope of protection. And so let me be clear, as of right now, as of today, the no social media account law in any state says thou shalt not consider public record information. No law says that. Some of them, though, go the other direction, say, hey, it is definitely okay to consider public information. And so certainly those states in blue, those legislatures wanted to call that out. For the other states in red, they're simply silent. Again, I think this is something where you're going to want to consult with your employment law counsel and just make sure you get his or her advice on, hey, I'm about to implement a social media screening program. I understand that there are laws in these states which govern social media accounts and they provide protections for workers. How does that impact my program? So what are the typical features of a social media account statute? Well, all of them say you cannot require the employee to divulge his or her user ID and password. They typically also say you can't require the employee to accept a friend request. You can't make them connect. The boss can't go to his team member or her team member and say, hey, I sent you a friend request on Facebook or Instagram. I need you to accept it. Can't do that. Typically, these laws also say you can't require that employee to sit there and log onto her account while you're watching behind, the chair. Okay, can't do that either. Can't do indirectly what you can't do directly either. Some states, some of them, will allow the employer to require the employee to share a user ID and password if the employee is conducting an investigation. it's got to be an investigation that relates to compliance with laws typically associated with alleged misconduct on the part of the worker. You usually have to have some very specific evidence that gives you a basis for going to the worker and asking for the personal online social media account access. I would highly recommend that before you ever do that, you consult with your employment lawyer and make sure that in the jurisdiction you're in, that you meet that statutory test before you sit down and do that. And then, as I mentioned before, some states go above and beyond and say, hey, look, if it's in the public domain, the employer is okay to consider it. So those are the typical features of the protected password law states. So we've got EEO laws you need to be mindful of. We have social media account laws that you need to be mindful of. So these are all states that have off-duty conduct laws. The ones in orange provide broad off-duty conduct protections. So California, Colorado, North Dakota, New York, and Connecticut, okay? So if you see someone engaging in conduct, you need to be very careful in those states before taking adverse action if there's, if it's conduct that would be legal in that state. I mean, the simplest example is marijuana consumption, right? If you're in Colorado and it's legal to consume marijuana and the person posts a picture of himself consuming marijuana, that would be an example of off-duty conduct, okay? And there are other examples. I mean, hunting, for example, could be considered one. So just be mindful of that. And if you're in those jurisdictions, please consult with your employment counsel before you see someone engaging in an activity on a social media report and you decide that that does not fit with your company culture and you're not going to proceed with that candidate because she posted, the fact that she was engaging in that conduct. The states in green have narrower off-duty conduct protections. In those states, it's focused on consumable goods. Tobacco is one that you'll actually find in quite a few states. So if someone's a cigarette smoker, you want to refuse to hire them because they posted a picture of themselves with the cigarette dangling out while they're on the deck of their boat or something like that. That would be prohibited under that state statute. So be mindful of that. And Connecticut in particular has a free speech protection for its employees under state statute, under state constitution. And so you're going to want to be mindful of possible free speech rights. By the way, if you as an employer are a government agency, then you may be obligated to pay attention to free speech protections that the worker may have. As a general principle, again, employees do not have free speech rights vis-a-vis private employers. But again, that's a general rule, and in some states they do. Consult with your employment counsel. Labor rights. We've actually seen a fair amount of labor case law on the area of employees exercising their labor rights. So the National Labor Relations Act says it's an unfair labor practice for every employer, okay, not just unionized employers, but for every employer to interfere with or restrain the exercise of rights that are guaranteed under the Act. Those rights include engaging in what's called concerted protective activity for the purpose of collective bargaining or other mutual aid or protection. So, for example, complaining about working conditions, complaining about pay. And so we see a line of cases, for some reason we're seeing them on Facebook in particular, where one worker will start up a chat with coworkers complaining about working conditions or compensation or a supervisor that they feel is mean or unfair or even abusive. Okay, this conduct may be protected under the National Labor Relations Act, even if the conduct is obscene, crude, vulgar, directed at a specific individual, including managers. So, you get some pretty rough language, some pretty salty language directed toward supervisors on, Facebook during a session where workers are complaining. That can be protected activity. So if you see when you go to run a social media report that the individual in question is talking about work-related matters, be careful, because it could trigger rights under the National Labor Relations Act. So this kind of leaves employers in this catch-22, right? On the one hand, you don't want to know information, certain information, so you can't be accused of violating laws that protect workers. But on the other hand, as a hiring employer, you need to know information because you got to figure out, first off, if they're qualified for the job. And secondly, you got to make sure they're not a reasonably foreseeable risk of harm. So I want to conclude here with some practical considerations, kind of gleaned from seeing social media reports and interacting with employers over the years. I can't stress enough, I like the idea of a committee and striving for continuity of reviewers, okay? That need for consistency. That's important when the content is so subjective. You may want to give account to cultural, political, and social economic behavioral differences. The more reports you see, the more you're going to notice differences in how people approach life, how they speak about life, and the kind of content they post. And what one cultural group may consider to be acceptable behavior, another cultural group may not. Be mindful of that. That might be a reason to have diversity on your committee to help bring the cultural differences to bear in your evaluation of these reports. One of the things you may find is a concept that I'm going to borrow from the law. This is actually a term that judges use, the shock the conscience standard. Like there's just no doubt, like this post well beyond the pale, like nobody's going to argue with it kind of thing. It may be helpful to consult with your employment lawyer about, hey, can we incorporate a shock the conscience standard? One of those things where, look, I don't have to debate this. Like everybody knows this is just not right to do. And it's therefore perfectly defensible to take action based on it. So talk with your employment counsel about that. Do you want to give advance notice to your candidates? This is something just to think about. Obviously, you already have to get their consent under the Fair Credit Reporting Act, right? A standalone disclosure that you're going to get a consumer report on them for employment purposes, okay? And their written authorization. But, some employers take it a step further and say, I'm going to look at your social media account. That might, again, you got to decide for yourself whether you want to do this, but you would think if the worker is smart enough and they would go make their account private, and thus it's private and it's just not an issue because it's not public anymore. So that's something you may want to give consideration to. And then of course certainly the person's position is something that's meaningful. I have tended to notice over the years that what really gets the attention of a company is when it's a person that's higher profile within a company, right? Someone who is an executive saying something shocking or offensive or culturally insensitive, intolerant, and that causes a lot of pain and heartache for going back to the Lisa Ellis. Okay, people were reaching out to the chief human resources officer of Mellon Bank and the CEO over the weekend, right? That's kind of stuff where you're going to be at home, you're going to be enjoying your Saturday afternoon, and all of a sudden your email gets blown up and people are ringing you on your cell phone because of some post that a prominent executive in the company made, right? So, it may be the case that you don't social media screen everybody in your company. Maybe you screen those that speak for the company, those that have a high profile position. Again, I've already said this, boy, some of this content can be offensive. It just really is. I mean, in preparation for this webinar and going through and selecting examples, you just kind of get disgusted. You're like, this is just obnoxious. Be aware of that because whoever you're going to ask to review this is going to have to put up with reading all that content. So you need to think through that too, because you're asking your HR worker, your HR colleague to be looking at some of this stuff, especially if you're doing high volume ordering. Again, do not forget, Fair Credit Reporting Act applies to this whole process. And so you want to be sure that you treat the social media report like you would any other background check report. I appreciate your time and attention this afternoon. I hope this has been interesting, enlightening, and illuminating. Thomas, do we have any questions that have come in that perhaps I might be able to answer?
Hey, Todd, again, thank you so much for spending your time with us today. So unfortunately, Todd, we are right at the end. Like we're very tight on time, so we don't have time for questions. We'll reach out to everyone who has a question after the conference. Thank you so much to everyone who attended. Thank you, Todd, for your time. Everyone, have a great day.
Bye.
Thank you. Bye-bye.